Sports governance. Sports awareness. Sports accessibility. Sports facilities development. Sports linkages. Institutionalization of the Philippine Sports Institute. Legislative initiatives and interagency collaborations. Bahagi na ng buhay nating mga Pilipino ang sports. Mula sa panahon ng unos, sa tamis ng tagumpay, sa kabila ng pagbabago ng buhay, ang Philippine Sports Commission ay patuloy na magigilingkod sa sambayanan at atletang Pilipino.
Hello, ladies and gentlemen. I am Atty. Joenar Pueblo, and it is my honor to lecture regarding Introduction to Alternative Dispute Resolution in Sports. This is sponsored by the Philippine Dispute Resolution Center Incorporated through the auspices of the Sports Committee of PDRCI. And with your permission, allow me to start. The title of my lecture revolves on the concept of sports lang. Our aim here is to give the listeners an idea of what is alternative dispute resolution. Ano ba ito? Paano ba ito makatulong sa mga atleta, sa mga sports managers, owners, and the institution in general? So we would also provide information on the various ADR mechanism that PDRC can offer the sports community. Further, we want to enlighten the sports community of the value of alternative dispute resolution in sports. So when we hear sports lang, when we are dealing with somebody in a competitive manner, and we want things to be fair, we want things to be reasonable, we say, pare, sports lang. Ma'am, sports lang. No? This Filipino terminology, which started as a sports terminology, has become a phrase which is also used all in commerce or even in our daily lives. No? We want to deal with a younger brother or sister in a competitive manner, we will say sports lang. Or kahit magano tayo, no? May kalaban tayo, magsuntukan tayo, sabihin natin, oh, walang problema, sports lang, ha? So, when we invoke the phrase sports lang, we want to say, let's do this fair. Let's do this in a manner that we are civilized, in a manner that we consider as reasonable. That's why sports lang is what we Filipinos say when we want to convey fairness, calmness, relax lang, cool ka lang, and reasonableness, even in the heat of confrontation. I'm sorry. Sports is defined by Boxell's The Ethics of Competition as a freely chosen, voluntary activity that is rule-governed and requires bodily excellence, which is highly or highlighted in competition. So it is freely chosen, meaning ginusto natin to. It is voluntary activity, but it's governed by set of rules. And it requires physical or bodily excellence, which is heightened in competition. So competition is defined, according to the Cambridge Dictionary, as a situation in which someone is trying to win something or be more successful than someone else. Thus, by nature, someone in the sports environment, kay atleta ka, kay coach, kay club owner, and kahit fan ka lang, no? Always desire to win. No? That is the nature of competition. Gusto nating manalo. That desire to win, dahil gusto nating manalo, obviously, magke-create yan ng conflict or dispute. Kasi, yung other side, gusto ring manalo. And sometimes, we want to win no matter what. Or we will do everything para manalo. These conflicts or disputes, if not immediately acknowledged and addressed, may be the very reason for losing. So, gusto kong ipakita na yung kagustuhan nating manalo, kasi dahil nasa environment tayo na tayo mga atleta, we generally do not want to lose. Or generally nga, kahit sino doesn't want to lose, no? But iba pa yung competitive spirit ng mga atleta. So, minsan, that concept of competition na dapat sa arena lang ng sports natin, lumalabas sa ating social environment. So minsan, kahit yung ordinary interaction natin with our fellow individual, becomes competitive. Ayaw rin nating matalo. Especially if it boils down sa conflict. Or kung may away tayo, away pamilya, away pag-ibig, or away in relation sa ating kontrata. No? So gusto nating manalo, generally. Kung hindi natin ma-address yan immediately, in the most peaceful way, may malaking likelihood na doon pa tayo matatalo. So, as athletes, imposible naman na wala tayong miscommunication, conflict, or dispute with a fellow athlete versus ating kupunan, with our coaches, with the owner of our league, so on and so forth. And ikaw kung bilang atleta, minsan magtataka ka, paano ko ma-resolve yung problema ko? Ang dami-daming mga bodies na nagre-regulate, na nagko-control ng aking action bilang atleta or bilang coach or bilang owner for that matter. So, the Philippine Sports Commission, the Philippine Olympic Committee, the various national sports association created clarifications kung saan ang mga jurisdiction ng bawat isa. So, yung Philippine Sports Commission, which reports to the President of the Philippines, is guided by obviously by the Constitution and Republic Act 6847. It is the recognized authority on amateur sports in the country. If the Philippine Olympic Committee reports to the International Olympic Committee, it is guided by the Olympic Charter and their bylaws. It is the recognized body in activities relating to events in the Olympic cycle. While the National Sports Association, of course, reports to their international federation. It is guided by the International Federation's constitution and bylaws. And it is the recognized authority on technical matters of their sports. So, what are the possible disputes or conflicts that an athlete, a coach, an owner of a sports organization will have to deal with? So obviously, it could be in relation to anti-doping, disputes relating to disciplinary action if you have violated the rules of the sports or the rules of your committee, issues on selection and eligibility, who should go to the Olympics, who is allowed or considered eligible to play, disputes relation to discrimination of athletes, either by gender bullying, and harassment disputes, employment disputes, and disputes occurring in the field of play or its equivalent in a particular sports. And lastly, I highlighted this in red, contractual or remuneration disputes. Disputes relating to anti-doping, disciplinary disputes, selection and eligibility disputes, discrimination, bullying, employment disputes, disputes occurring in field of play may be handled by these various elite sports organizations by the Philippines. Of course, these organizations could also deal with your contractual or remuneration disputes, which deals with ano ba yung content ng kontrata mo? Magkano ba ang babayaran sa'yo? Sino ba magiging liable if there is breach of contract? Ano ba ang content ng mga contract mo? So, these issues requires a specialized organization. And we at Philippine Dispute Resolution Center Incorporated would like to offer our services because we are highly specialized in handling so-called disputes in relation to contracts. I am proud to inform you that the PDRCI is the premier alternative dispute resolution institution in the Philippines. The alternative dispute mechanism that we want to offer you hopefully provides a solution to sports-related contractual or remuneration disputes that adheres to the principle of sports law. No, we want, in relation to any conflict or dispute that you have to deal with your fellow athlete, with the owner of the ball club or the sports club that you are under, in relation to your contractual disputes, you can resolve it, or both parties can resolve it in the most sports lang manner, which, as I've said a while ago, is the most reasonable, fair, and calm, wherein after you resolve the dispute, your relationship would still be intact. Even if the way we will handle our negotiations, our mediations, or if it goes to arbitration, will still be considered, or our relationship will still be considered good, fair, and reasonable. So, before we go further, ano ba tong alternative dispute resolution? Ano ba tong gusto naming i-project na mode of resolving yung away nyo or hindi pagkakaintindihan base sa kontrata nyo? And paano namin mapapakita sa inyo na sports lang ang mangyayari after we resolve our disputes? Na ang ating relationship will still be intact. So, ang alternative dispute resolution is a mechanism to resolve ongoing or future disputes between parties in a contract without the need of court intervention. Ibig sabihin, may paraan na kahit hindi tayo nagkakaintindihan sa ating kontrata, may mekanismo na pwede nating ma-resolve ang ating conflict kahit tayo ay mga competitive na tao na hindi mo kailangang dumaan sa korte. Kasi alam natin, kapag dumaan yan sa korte, yung relasyon of all likelihood will be severed. Because kung ikaw naka-experience ng court litigation, the fact that you are going to court, it's already a stressful situation. Much more that you have to present your evidence, the other party will present their evidence, and kailangan magsalpukan ang evidence mo laban sa evidence ng isa. Dahil mga atleta, mga coach, or those who are in nasa sports environment are very competitive people, the general tendency is hindi tayo magpapatalo. Ayaw nating matalo. Masakit ang matalo. But may paraan na hindi kailangan lahat tayo talo. Pwede tayo mag-win-win situation through a mechanism na tinatawag namin alternative dispute resolution. Anong advantage of ADR? Sabi ko nga, like the concept of sports lang, ADR is based on reasonableness as it is generally inexpensive than litigation. It is fair as it is impartial. It is calm because we rely on speedy disposition of disputes, which generally ensures that the relationship is intact. Alam natin sa korte, matagal mag-resolve ang huwes. Kasi maraming kaso na kailangang i-resolve ng korte. At ang korte, minsan, yung kakayahan niya ay tinatawag naming general jurisdiction expertise lang. Meaning, sa mga bagay na considered highly technical, at the very least, yung judge or magdi-decide ng kaso mo needs to extensively study. So usually, a sports-related dispute, especially on its contractual level, is highly technical. May lingwahe ang sports na minsan hindi ginagamit sa ordinaryong pag-uusap ng mga tao. So kailangan ang nag-handle din o magre-resolve ng dispute mo is someone that is highly technical or knows the language of your sports also. And we are proud. Now with ADR, it is faster to resolve it through this mechanism kaysa sa korte. Dahil through ADR, bawat party kasi could agree kung gaano katagal dapat matapos ang isang kaso. Kayo yung nag-a-agree kung ilang buwan lang and dapat matapos ng kaso. Kung sino ang magre-resolve ng inyong dispute na may area of na may kaalaman technically sa inyong sports. Dahil mabilis ang pag-resolve nito, it will be cheaper. Alam mo na ang dispute mo, the person that is helping you resolve your dispute, nakatutok lang sa kaso mo. And the intention of the whole process is to make sure that your relationship, both parties, is still intact. So, magtatanong ka, ibig mo sabihin, kahit walang huwes, walang korte, pwedeng ma-resolve yung kaso ko? Paano ba yun? Ano bang basihan nyo na pwedeng ma-resolve ang kaso ko, ang dispute ko, na hindi dumadaan ng korte? Sa legal na konsepto, may tinatawag kaming doctrine of pacta sunt servanda. Ang clause ng kontrata mo will be the law between you and your other party. Ang konstitusyon mismo nag-a-acknowledge sa sanctity of contracts and agreement of parties under Section 10, Article 3 of the Bill of Rights, when it stated, no law impairing the obligation of contracts shall be passed. Kaya, when parties provide a clause where the referral of their disputes should be in another mechanism aside from the court, it should be honored and complied with. Ibig sabihin, kung sa kontrata mo, may dinagdag ka na provision or mechanism na sinasabi ng mekanismo ng kontrata mo na kapag tayo hindi nagkakaintindihan, wag na tayong pumunta sa korte. I-resolve natin using alternative dispute resolution. Either mag-negotiate tayo, mag-mediate tayo, or i-arbitrate natin ang ating conflict. So lumabas itong mga terms na to, negotiation, mediation, and arbitration. Don't worry, as I proceed, I will explain these various ADR mechanism. Magtatanong ka, teka muna, yung pinirmahan kong kontrata, parang walang ganong provision. Huwag kang mag-alala. I will explain it also kung paano na kahit sa kontrata mo na yan, walang ganong provision, pwede ka pa rin o pwede kayo ng other party, ng coach mo, ng boss mo, na may-ari ng kupunan, na mag-resolve ng dispute nyo through ADR. The point here also is that assuming magpipirma ka ng kontrata ngayon, at least ipasok mo na sa isip mo, siguro yung kontrata ko, I should include yung sinasabi ni Atty. Pueblo na ADR clause. Ayoko na dumaan ang problema namin ng kupunan natin as an atleta sa korte. Sasabihin ko sa nagda-draft ng kontrata ko, boss, attorney, sir, baka pwede mong ipasok sa kontrata ko ang tinatawag ni Atty. Pueblo na ADR clause. So, what are the laws that is affirming alternative dispute resolution? Meron tayong Republic Act 876, an act to authorize the making of arbitration and submission agreements to provide for the appointment of arbitrators and the procedure for arbitration in civil controversies and for other purpose. Take note, bantayan nyo ang term making of arbitration and submission agreements. Kasi as I go on with my discussion, magiging importante, especially ang term na submission agreement, kung ang kontrata mo walang arbitration clause or ADR clause. In 2004, may pinasa na law which is known as Republic Act 9285. It is an act to institutionalize the use of an alternative dispute resolution system in the Philippines and to establish the Office for Alternative Dispute Resolution. Ibig sabihin nito na ang alternative dispute resolution ay nasa sistema na ng Philippine society. Ina-apply na under Philippine law and pwedeng i-invoke or gamitin ng kahit sino kung gusto niya ng mabilis, ng madali, at para sa ating mga atleta, sports lang na pag-resolve ng dispute. So, naalala niyo kanina yung tanong na binigay ko? Or ang tanong na baka nasa isip nyo? Paano ko ADR ready ang kontrata ko? What if ang kontrata ko na pinirmahan walang ADR clause? So, kung wala ka pa nakapirma, if you have not signed any document, as I've said a while ago, my advice is you provide an ADR clause rather than a litigation clause in your sports contract. Lahat kasi ng kontrata, before the advent of ADR, or before ADR became popular, kapag may conflict sa isang kontrata, yung sinasaad sa kontrata is, kung hindi tayo magkakaintindihan, ang ating dispute should be resolved under the jurisdiction of the Court of Makati or under the jurisdiction of the Court of Iloilo, Court of Quezon City, whichever is convenient para sa inyo, or as provided ng kontrata. Pero ang dispute mechanism mo o ang remedy mo kung hindi kayo magkaintindihan sa kontrata, or kung ang kontrata mo ay na-breach, is mag-file ka sa korte. Ang kind of mechanism na yan ay tinatawag naming litigation clause. Yung advice ko is para sports lang ang pag-resolve ng dispute mo. Sabihin mo sa abogado mo, sabihin mo sa gumawa ng kontrata, kung pwede, ADR clause ang isaad sa sports contract mo. Pwede mong sabihin na, boss, baka ipasok mo dyan na dapat may negotiation muna. Or mediation. Or kung hindi natin ma-resolve sa negotiation, mediation, i-arbitrate na natin. Huwag lang tayo pumunta sa korte. Kasi ang energy ko, ang time and effort ko para mag-practice, mag-ensayo, para ma-hone ko ang aking craft, para maging magaling akong atleta, mabuburo kung nandun na ako palagi sa korte. Maghihintay hanggang tinatawag yung kaso ko. So it's a very big advantage para sa atleta na kung may dispute sa kanyang kontrata na may ADR clause. Yung sinabi ko nga a while ago, what if nakapirma na ako ng kontrata, patay, attorney, wala na. May pinirmahan na akong kontrata, walang ADR clause. Ikaw at yung other party, either ang kupunan mo, could actually sign another agreement to submit yourselves to adopt ADR mechanism. Yun yung naalala mo, tinawag natin na submission agreement. You could create a separate document or contract na wag na tayong pumunta sa korte, boss. Pirmahan na lang tayo na isubmit natin ang ating dispute or conflict using an ADR clause. Adopting ADR mechanisms. So, ano ang mga basic ADR mechanisms na pwedeng gamitin ng isang atleta? Of course, maraming iba pang ADR mechanism. But sa tingin ng PDRC, yung pinaka tailor-made para sa sports are negotiation, mediation, at saka arbitration. Itong mga ADR mechanism, ang pinaka-the best na mechanism na maipapakita sa atleta, sa kupunan, sa organisasyon, na kahit tayo may conflict, kahit tayo may dispute, pwede nating ma-resolve to na sports lang. So, himay-himayin natin ang different ADR mechanism na gusto naming i-recommend sa inyo. So, umpisahan natin sa negotiation. So, obviously, negosasyon, dalawang tao will try to discuss with an aim at reaching an agreement. So, pwede nating pag-usapan muna. Ikaw, saka assuming ang other party is either yung coach mo, fellow mo na atleta, si manager, or si owner ng kupunan, pwede tayong na, boss, baka pwede nating pag-usapan. I-negotiate natin. Baka pwede nating madala to sa simpleng at mahinahon na pagtalakay. Alam ko, medyo nagtatampo kayo. May tampo rin ako. Pero baka pwede nating pag-usapan. Yan yung basic tema ng negotiation. Ang maganda sa negotiation kasi we are all inherent negotiators. Because life is always a constant negotiation. Kaya lang, minsan there are those that are better than others. However, huwag tayong matakot mag-negotiate. Huwag tayong matakot na mag-reach out to the other party. And assuming ngayon, nag-fail ka sa negotiation mo, at least you could say you tried. And your experience in the process of negotiation, baka magamit mo sa isa pang future dispute mo. And by this time, you could, with your experience in your previous negotiation, that future negotiation would become more successful. Negotiation is also considered as the art of getting what you want while making the other feel that they got what they want also. So, win-win situation. Happy ka, happy siya. O kahit hindi ka happy, hindi rin siya happy, pero at least na-resolve nyo ang dispute nyo. Kasi minsan, whether you like it or not, kapag nag-negotiate kayo, may give and take din yan. Minsan, okay, gawin mo to, or I'll agree to that, as long as you agree to this. Kung kukunin mo yan, dapat may kukunin rin ako. So the point is, pwede mong ma-resolve ang conflict mo, ang dispute mo, through negotiation. And at the end of the day, pwede mong sabihin, pare, sports lang ha. So pag-usapan natin. The other one is what we call mediation. Ang definition ng mediation under the ADR Act is a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. Naalala mo kanina, sabi ko, negotiation, pag-usapan natin. Minsan nga lang, as I've said, may mga mas magaling na negotiator kaysa sa'yo. Or even both parties. Or minsan, hindi mo talaga sasabi lubos ang gusto mong sabihin. Kung ikaw lang. So, pwede kang kumuha ng third party na alam mong may expertise sa sports mo or properly trained sa ganyang klaseng pamamaraan ng pag-resolve ng dispute or magaling ring mag-negotiate. At kung ikaw at yung other party mag-agree sa taong ito na siyang tutulong sa inyo o mag-a-assist para ma-resolve ang dispute nyo, ang tao na yan, ang tawag nating ay mediator. And ang buong proseso ng pagtulong ng tao ng mediator na yan is ang process ng mediation. So, mediation is negotiation assisted by a third party who has the expertise to bring parties together to reach an agreement. So, sino to si mediator? Anong dapat niyang gawin? The mediator explores the views, perspective, position, and even feelings of the party to discover whether the parties has a common ground to make concession. Si mediator should have the skill na alam niya kung ano ang hugot mo at saka ano rin ang hugot ng other party. Kung alam niya kung anong hugot mo, kung ano yung hugot ng other party, baka pwede niyang hanapan ng common ground. So that maka-reach kayo sa isang concession or agreement. Ang mediator is a facilitator of understanding and movement, and is best if he or she does not express her personal views on the merits of the party's dispute. Ang mediator, ang main role niya is tulungan kayong dalawa na maka-reach sa isang common ground, sa agreement. Hindi dapat siya yung atributo na, oh, dapat ganito, dapat ganyan. Of course, kung gusto nyo, dalawa, na ganyan yung ugali ng mediator, kasi kayo rin mag-a-agree, then that mediator could do that also for you. Pero, ang best way is, ang isang mediator is tumutulong sa'yo kung ano yung hugot mo, ma-verbalize niya, ma-explain niya, ma-summarize niya sa other party, without the other party, impossible na hindi rin masasaktan, na pang sports lang din. Same thing, na ang hugot ng other party, ma-capsulize niya, na pagdating sa'yo, ay madali mong maintindihan at hindi ka masasaktan. So that, makita mo rin yung perspektibo ng other party. Ah, kaya pala ganun. Kaya pala sila galit. O yung other party, maintindihan rin kung saan ka nanggaling. Ah, kaya pala. Yun pala, bakit niya ginawa yun? Bakit hindi siya nag-practice? Bakit gano'n na yung, bakit hindi niya kinumply yung kontrata? So on and so forth. No? So, yun ang pwedeng gawin ng mediator para sa inyo. And as I've said, no, kami sa PDRC has the expertise, the knowledge, the capability to help you out as mediator. Kung paano namin kayo tutulungan through PDRC ay i-explain ng mga iba kong kasamahan. Saka ang concept ng mediator will be discussed further by my fellow lecturers also. So, the moment ma-approve na yung nag-agree na kayo, gagawa kayo o pipirma kayo ng settlement agreement or compromise agreement. Basta bantayan nyo lang pag gumawa kayo ng agreement, make sure it's ironclad, yung term namin. No? Para pag pirmahan nyo, tapos na. Wala nang mga gray areas or issues. To avoid circumvention or breaches or even unnecessary clarification on the signed agreement. The main purpose of mediation is to assure the termination of disputes and the proper compliance by parties. So, kung gusto nyo, hindi nyo ma-express yung sarili nyo, hindi kayo magaling na negotiator, pwede kayong kumuha ng mediator. Paano nyo gawin yan? Balik ulit tayo. Ilagay nyo sa kontrata nyo na kung may conflict tayo, gusto ko, i-negotiate muna. Kung hindi madalas ang negotiate, kuha tayo ng mediator. Natutulong sa ating i-resolve. So, yun yung clause, no, na tinatawag naming ADR clause. Ilagay mo yan sa kontrata mo. At kung wala yan sa kontratang pinirmahan mo, pwede kayong gumawa ulit ng dokumento na sinasubmit nyo ang sarili nyo sa negotiation, mediation, and later, the one that I will discuss, arbitration. So, what is arbitration? So, this topic will be discussed extensively by our chairman of the Committee on Sports Arbitration, Dr. Charlie Ho. But allow me to give you a brief insider of what is arbitration. So, arbitration is an alternative dispute resolution mechanism where parties to a contract or by way of submission agree to resolve their dispute by choosing an unbiased third person, isang tao, or tribunal who shall issue an award after hearing the said parties. Now, kung hindi madala sa mediation, yung conflict ninyo, pwede nyong isabay sa kontrata nyo na kung hindi natin ma-resolve sa mediation, i-arbitrate na lang natin. Sa arbitration, may magdidesisyon. Either isang tao na pinili nyo, dahil kayo nagpili, of all likelihood, yung pinili nyo, marunong sa sports or technical matters ng kontrata nyo. Kung isa lang yung pinili nyo, both parties agree to one person, ang tawag namin dyan, sole arbitrator. But if you agree na ikaw, bilang claimant, pipili ng sarili mong arbitrator, while the other party, pipili rin ng sarili niyang arbitrator. Yung dalawang arbitrator na yan, ay pipili ng isa pang arbitrator na mag-a-act as chairman. At ang tatlo na yan will resolve your conflict. Ang tatlo na yan ay tinatawag namin na arbitral tribunal. So papakinggan nila ang side mo where magpe-present ka ng evidence. Yung other party also magpe-present ng evidence. They will resolve it through what we call an award after hearing the parties. So parang korte rin, magpe-present ka ng evidence, magpe-present ka ng witness, at i-resolve nila. Ano naman ang kaibahan ng arbitration sa korte? Kasi ang arbitration, especially kung PDRCI arbitration yan, hindi yan susobra ng 6 months to 1 year. Generally nga, 6 months lang. I-discuss yan further ng executive director ng PDRCI. But ang point ko is, mabilis ito. Hindi to aabot ng 1 taon. Sobra na nga yan. Pero kung sa korte ka, sigurado ko, yung minimum time period to resolve your conflict will be 3 to 5 years. Anong gagawin mo bilang atleta sa buong time na may kaso ka? No? So, madidistract ka. Yung utak mo na sa kaso na. Ang maganda pa sa arbitration is, usually ikaw lang yung kaso nila. Wala na silang ibang kaso. Ikaw lang. Sa arbitration, katulad ng mediation, may tinatawag kaming party autonomy. Again, yan i-discuss rin ulit further ng mga lecturers. Ibig sabihin ng party autonomy is yung kayong dalawa na partido na gusto nyong i-resolve ang kaso nyo, kayo yung nagdidikta. Kailan nyo gusto mag-hearing? Gaano katagal ang hearing? Ano ang proseso or procedure natin sa ating hearing? Kasama na rin yan kung sino ang gusto natin na i-appoint na mga arbitrator. Ibig sabihin, pag-start ng hearing, hindi na kayo maghihintay. Umpisa na agad. Dahil kayo lang ang tinutukan ng tribunal na yan or ng sole arbitrator. No? So, remember the word or the term party autonomy, or may kakayahan kayo na magdesisyon kung ano ang proseso, kung paano nyo i-resolve ang conflict or dispute nyo. So, tingnan natin kung gusto mong piliin yung mode of resolving your dispute. Ito yung chart na hopefully makatulong sa inyo. Kung gusto nyo na may more control kayo over the outcomes ng dispute nyo, you will either go to negotiation or mediation. Huwag nyo lang intindihin yung expert determination. Kung gusto nyo na kayo lang ang involved sa kayong opposite party, you go ahead with negotiation. Pero kung medyo hindi ka confident sa sarili mo to solve your dispute, gusto mo ng isang tao na capable, na you could trust to help you facilitate negotiation with the other party, then you take up mediation. Kasi in negotiation and mediation, ang partido ang may control over the process and outcome. Ang focus ng pag-resolve nyo ng dispute is consensus. Kung ano yung ma-agreehin ninyo. And generally, walang procedure to. It's informal. Depende sa ano nyo. Depende kung ano ang proseso na gusto nyo. Pero generally, napag-agreehan nyo yan. Pero walang strict rules. Kaya nga, informal. Yung negotiation at mediation, kung hindi ka pa makapirma ng submission agreement ninyo, or rather ng contractual agreement ninyo, anytime both parties could back out from both the negotiation or the mediation. So during sa mediation nyo, or rather sa negotiation, ako parang di tayo magkakaintindihan, wala na. Wala na. Sorry. So hindi, kahit pa nga may agreement kayo, hanggat hindi yan nakasulat, hindi kayo mababound ng pinag-usapan ninyo. Same with mediation. Kahit tinulungan kayo, hanggat hindi kayo nagpirmahan, anytime you could back out. By the way, another aspect ng mediation is it's usually confidential. So anong pinag-usapan nyo sa mediation? Hindi pwedeng gamiting evidence against sa inyo. Assuming may failure of mediation and then you go to arbitration, or eventually gusto nyo pumunta ng korte. Hindi nyo pwedeng gamitin ebidensya, o yung sinabi mo during mediation, ganito. Di ba sinabi mo yan? Ipipresent ko yan sa korte or sa arbitration. You cannot do that. Unless the other party agrees to remove that confidentiality. O mag-agree yung party na, o sige, yung information based on our discussion, pwedeng gamitin sa arbitration or sa litigation. So, yon ang characteristic ng both negotiation saka mediation. No? Yung control over the outcome of the dispute sa inyong dalawa. Yung negotiation, kayong dalawa lang. Yung mediation, may third party na tumutulong sa inyo. Kung gusto nyo naman na ibang tao ang mag-decide ng outcome ng inyong dispute, pero ayaw nyo na pumunta ng litigation, kasi ang litigation, public, ibig sabihin, lahat ng tao na nasa loob ng korte na yan, na kung saan mo final ang kaso mo, maririnig ang problema nyo. Kahit yung naka-orange o naka-yellow, ibig sabihin yung mga preso, maririnig ang problema nyo. Sasabihin nila, naku, si atletang ganito pala, ganito, ganon. Ito yung ginawa niya. Naku, si kupunan. Ito yung ginawa. No? So, malalaman ng publiko ang pinag-aawayan nyo. Yan ang litigation. Or yan yung isang characteristic ng litigation. Pero kung gusto mo na hindi malaman ng ibang tao kung anong problema nyo, kung anong dispute, anong conflict nyo, pero gusto nyo may magdi-decide na ibang tao, then I advise you with arbitration. Kasi ang arbitration tends to be confidential. Ang mga bagay na diniscuss sa arbitration are generally confidential. Hindi pwedeng ipalabas sa publiko, and usually private ang setting while you are hearing it. Ang confidentiality na yan, at kung naalala nyo yung party autonomy, are mga characteristics ng alternative dispute resolution. This will also be extensively discussed by my other lecturers. So, sa uulitin, kung gusto mo na ibang tao na may expertise, may kakayahan, ang magdidesisyon ng outcome ng dispute nyo, gusto nyo siyang maging confidential. Gusto nyo siyang maging mabilis. Gusto nyo siyang na kayo ang may control in a way kung sino ang magdi-decide. Then I advise arbitration. As I've said, a third party controls over process and outcome. Ang pag-determine yan is legal. Formal rin yan kasi may rules kayong that you have to agree with. And remember, the moment this is resolved through an award, it is generally final and executory, and hindi mo yan maa-appeal. General yan, ha? I-discuss yan extensively ng lecturer for arbitration na si Dr. Charlie Ho. So, ito ang pwede namin ma-offer sa inyo sa PDRCI na related sa konsepto na sports lang. Gusto nyo ba ng isang way to resolve na reasonable, kalma lang at mabilis? These are all characteristics na makikita mo sa alternative dispute resolution. Can it be negotiation or mediation, assuming you want full control of how you want to resolve your dispute. Or if you want na ibang tao ang magdi-decide with finality, and that is arbitration. Negotiation, mediation, arbitration are ADR resolution modes that are speedy, mabilis. Kasi as sinabi ko a while ago, hindi yan susobra ng 6 months actually. Especially if it's a sports dispute. Because under our rules, sa sports arbitration rules or sports mediation rules, dapat matapos yan ng mabilis. I-expound yan ni Executive Director ng PDRCI, Arleo Magtibay. Gusto mo na may control ka? Party autonomy? Gusto mo na confidential siya? Then, ADR is for you. And I advise that you should. Because with ADR, there is a big likelihood that you will be able to dispute or to resolve your dispute not only speedily, not only with less cost, with your ability to dictate it and being confidential, but the likelihood that your relationship with the other party will still be good. That the whole process of dealing with your conflict revolves on the concept of sports lang. And we at PDRCI, which is considered the gold standard in ADR resolution of conflicts, are considered experts, well capable of resolving your dispute using alternative dispute resolution mode. It goes back to you to choose to use ADR. Huwag tayong maging ADR claustrophobic. No? Huwag tayong magpapadala sa takot na parang hindi ako familiar niyan. Paano ba yan? Baka magka-problema ako diyan. With all my discussion, obviously, for you to embrace ADR is to not be afraid to adopt ADR, to put an ADR clause in your contract, or to demand or request to put an ADR clause in your contract. No? Huwag tayong maging ADR claustrophobic, because ADR claustrophobia is the fear of using an ADR clause in contract drafting or adopting an ADR mechanism. I am proud to say that it is I coined this term, no? ADR claustrophobia. My advice is huwag kayong matakot na sabihin sa nagda-draft ng kontrata nyo, pwede boss, lagyan mo ng ADR clause yung kontrata ko. Yung may negotiation, may mediation. Or kung hindi natin madala sa negotiation sa mediation, i-resolve natin sa arbitration. Kasi daw, mabilis. Dahil mabilis, hindi magastos. Hindi malalaman ng ibang tao yung problema natin because confidential daw. Tayo yung didikta ng procedure. Kailan yung hearing? Gaano katagal ang hearing? Paano natin i-resolve? Dahil may party autonomy. Siguro mas mabuti ito kaysa pumunta tayo ng korte. Na doon, at the very least, ma-resolve ang kaso natin 3 to 5 years. Mag-aaway tayo kasi confrontational yung litigation. Malalaman ng publiko kung ano yung pinag-aawayan natin. Hihintayin pa natin kung kailan tayo tatawagin. Yun pala, ipopospone lang. So on and so forth. So, don't be ADR claustrophobic. Take a shot at PDRCI sports ADR mechanism that can help you settle your disputes. Because at the end of the day, dapat lahat sports lang. With that, thank you very much for listening to me. This is Atty. Joenar Pueblo in behalf of PDRCI, signing out.
Bahagi na ng buhay nating mga Pilipino ang sports. Mula sa panahon ng unos, sa tamis ng tagumpay, sa kabila ng pagbabago ng buhay, ang Philippine Sports Commission ay patuloy na magigilingkod sa sambayanan at atletang Pilipino.